Our presenters today are Tom Nicholson and his daughter Melissa Nicholson Bright from Nicholson Law in Sioux Falls. Tom grew up in Winter, South Dakota, and he received his undergraduate and law degree from USD. He has had a private practice in Sioux Falls for a number of years and is now practicing with his daughter, which I think is pretty awesome. He has been a member of ABOTA, which is the American Board of Trial Advocates, and the South Dakota Trial Lawyers Association. He's been a past president of the South Dakota State Bar and served as a co-chair of the disciplinary committee, and also for quite a number of years as a bar examiner, I think from '88 to 2002. So a lot of good service to the bar during that period of time. Tom has also served on a number of boards in Sioux Falls. Just to name a few, he was a board member of the Sioux Falls Literacy Council, the South Dakota Humanities Foundation, and the Westward Ho Country Club. But really, that just names a few of the boards he's been involved with. He's been very active in the community. I mentioned that he practices with his daughter Melissa, and are pleased to have her here today also. She grew up in Sioux Falls, South Dakota. She's a graduate of DePauw University, where she played college basketball and majored in math. And then she came back to the University of South Dakota for law school, and I know has enjoyed practicing law with her father. So we're pleased to turn the time over to them.
You memorize all of that?
I didn't even know I was going to be here.
That's incredible.
No, but that's why I had my phone.
Welcome. As you know, our subject today is family law, and family law is probably the one area of the law where you touch all areas of the law pretty much, because divorce clients come from all walks of life. You might get a businessman who is worth a few $1 million, and you might get someone who doesn't have any money. So, and you might get people that have children that are an issue in the divorce. Or you might get people that are just older and they're splitting the ways and they just have money to fight over. And the key element of divorce law, family law, is, I think, the attitude and the comportment of the lawyer that is hired to represent someone. And the reason I start with that is that and I'm subject to it once in a while too, divorces can be very emotional. And some of it is fueled by what people see on TV. They have expectations of what divorce lawyers do. And some of it is fueled by just the personality of the lawyers and how they interact with their clients. And so I'd like to start this by just mentioning to you that there's only one stabilizing factor in most divorces, and that's the lawyer. And so if you are an aggressive person who likes to throw flames at people and get emotions fired up, and there are lawyers that do that, it's a real disservice to the client, because all it does is make it worse. And if you have a client that wants you to be really aggressive, you have to learn how to deal with that. And you have to be able to relate to them in a way where they feel you really care about them and that you really want to present their case for them and you do care about them, but that you are the white hat. You're not somebody who's, I'll give you an example. When Judge Keene, who's now retired, he had two young lawyers in front of him a few years ago, and they represented obviously the two sides of the divorce. And when you do discovery in a case, which is what your drafting assignment will be about in here, which is some interrogatories, you can ask the other side for certain information. And there are rules to play by. You can't ask for anything. You have to go by the rules of discovery. And these two particular lawyers were sending interrogatories back and forth to each other. And when you object to the other's interrogatories, or you just don't answer them, the remedy is to make a motion to compel, which is you go in front of the judge and you say, Judge, this person isn't answering them, they should, and you give all the reasons. And you can ask for terms, which are basically attorney's fees or some kind of a monetary penalty for making the other side have to come to court to get information they should have answered anybody. Unless, of course, you're right and you were right to object. Judge Keene had this case where there were 11 motions to compel, with a case where the people didn't have hardly any money. And those are two people that were trying to impress their client and make their client feel that they're tough or something. And that's what happens in divorces. And Melissa does more day-to-day divorce work than I do. I do a lot of civil work too. And I do some divorce. I used to do a lot more divorces, and now I just do a few. But she's always coming in my office and telling me a story about how somebody is driving her nuts and making them do all these things that are unnecessary. And I wanted to start this by mentioning that because that's not the type of person you want to be if you do family law when you get out. You want to be the reasonable one. You want to be the one that can stabilize the divorce and do what your client hired you to do, which is to keep the cost down and get a reasonable result. The other thing you have to think about are families, because oftentimes mothers and fathers, brothers and sisters get in there and stir the pot. And sometimes they're the ones that come in and try to hire you, because the person coming in, particularly parents, they may not have money. And so you have to really know your ethical boundaries and who your client is and who you're dealing with. Would you wear that jersey today if they had lost?
Probably not.
So let's go back to the kinds of clients you get. They come from, like I said, all areas of the law of the world, and so that you have to know all areas of the law. You've got to know real estate, because maybe there's a farm involved, a house involved, and how to draft deeds. You got to know how about financing and mortgages and all those kinds of things. You have to know about business law, because maybe somebody owns a business. You have to know what it's worth. You need to be able to read a balance sheet and income statement and those kinds of things. You might have to know debtor-creditor law, because maybe there are a lot of debts in there, or bankruptcy. And I don't know bankruptcy law at all, but you need to know enough to have a bankruptcy lawyer get involved, because that maybe gets a little more specialized. You need to know a little bit about taxes, because if they sell a business, they sell a farm, whatever, what is the net result tax-wise? You need to know the accounting things. I said, balance sheet, income statement, some of those kinds of things. Maybe a person owns a business and they say, yeah, but I lose money all the time. Well, of course they are going to say that, because if they own it, they don't want to give it up and they want it valued as low as they can. So you need to know how to work your way through that and get through kind of the spin that the other side puts on their case and get right to the heart of it. And those are the areas of the law. Those are just a few. I'm sure I missed some. So you know that when somebody talks to you about real estate, you just need to know real estate. And they talk to you about contracts, you just need to know contracts. But you really do have to be kind of an all-inclusive person to do divorce law. I was on the disciplinary board for a full term, and I would say that 70% of our complaints that came to the disciplinary board were either from criminal law or family law, and a majority of that 70% was family law. Because of the emotions involved, because a lawyer missed a tax analysis that cost somebody a bunch of money, or they missed, or what you have to do, you have to read the Ben Eicher case. I don't know if you've had that. It's not about divorce law per se. It's an ethics disciplinary board case, and it'll tell you how not to be as a lawyer. Mr. Eicher was a lawyer in Rapid City, and basically he was just obnoxious to other lawyers and how he treated other lawyers and how he comported himself. But you need to read that case, because that'll remind you, it should bring you back to square one and teach you that it's about being a good person when you're dealing with people. The other thing is judges. If you're a flamethrower and you cut corners and you don't tell the truth to the court, or you just cut corners a little, or you omit things, you think you're being okay because you omit things, you don't really lie, judges will pick up on that. And there's a lot of opportunity in front of a judge when you have a hearing to just say, Judge, I don't think we should do it this way or that way, or I don't think that all the facts are on the table from the other side, or maybe they're questioning what you've done in a motion to compel or something. If you have a history of going to court and cutting corners, the judges find out, and pretty soon you have no credibility. You have no integrity with the court. And that usually happens to people that are really aggressive. And so the images that you may get from some lawyers or even watching TV is just turn it 180 degrees and think of it opposite of that. The other thing is, if you have a general practice of law, which most people in South Dakota do because we don't have enough population to have that really close niche in the law, divorce law is a very good place to build your practice, because there probably isn't an area of the law that gets more referrals if your client likes you than divorce law. Because if you go to a party, if I go to a party in Sioux Falls is just big enough. It's not a big city, but it's just big enough where people don't know the names of any lawyers unless they've dealt with them or unless you're a divorce lawyer. If you go to a party, there's 30 people at a party, someone there's been divorced, someone there talks about someone, and they know divorce lawyers. Rico Johnson in Sioux Falls is a divorce lawyer. If you go to a party, I challenge somebody to go to a party of 40 or 50 people, and somebody, or if not, a majority of them don't know that name. If you go to a party and the best civil trial lawyer in the state that all the lawyers know about is brought up, no one there unless they've had that person for a client will even know who they are, because of the networking that people that have gone through divorces do, and they talk to their friends and they have friends help them through divorces. And the other thing is those people have other issues. Like I said, they come from all walks of life. So they're a great source of referrals for their own work, like they might later on need business contracts or something like that. The other thing that you have to be very aware of when you're practicing in front of a court is it's very easy when, particularly in a divorce trial or a hearing or something, to let the other lawyer get under your skin. So, this all seems like one constant theme I'm talking about, but it's the most important thing there is in divorce law. It's more important than interrogatories or how you draft your complaints or how smart you are in doing your research. If you don't have that one element, you're never going to be a very good divorce lawyer. You might practice it your whole life, but you're not going to get the referrals from, you'll get some, but it'll be the same kind of clients that liked you because you caused trouble for the other side and just ran up the attorney's fees. So always keep that in mind when we're going through what we're going to go through. Okay? I mentioned in the outline about some statutes. Those are just statutes that deal with discovery, written discovery, and we'll get to that a little later. And I cited to you just 25.4, which is a divorce part of the code. But and then part 2 of the agenda was just this real general overview that I wanted to visit with you about. But I think that it's important also to see what a divorce file looks like from start to the end. And I've given, I think you all have a packet, it's a sample packet. It's not perfect. That, for example, the stipulation that you got is just a made up sample from last year's teaching class that I did. And so there might be some typos or something there, but I wanted you to just see what that looks like. And Melissa really deals with those packets more on a day-to-day basis, so I'm going to let her talk about that packet and kind of go through what a divorce file looks like.
You want to share?
Yeah. That's okay.
Okay. I think I'm just going to talk off the cuff from what I do every day. I didn't necessarily prepare anything, but I think you already heard this, but I really want to reiterate. You can look at this packet, and you can kind of chronologically know what order you're going to do everything in, but there's definitely the science part of it or the procedure part of it, since we're not in science, but there's also, I think, the art of doing it in a way that gets you from start to finish in the most reasonable way, and probably what's best for your client, even if they don't know that, because they oftentimes don't, honestly. And unfortunately, I don't think there's really any way to figure out what works until you do it. You kind of have to stumble through doing some to learn what matters. So when people come in, and I think I just jotted down about 5 things that came to mind that are probably some of the most important things to just maintain throughout a case. But organization, communication with your client, and probably explaining and giving them options so that they understand what their options are, but then they understand what happens when they choose certain options in terms of their case, the complexity of it, in terms of the cost of it, in terms of what the other side will then likely do in response, and educating them on when they come in and they say they want to do X, Y, and Z. You actually say, okay, well, here are your options on those things, and here's what those decisions are going to look like if you actually do them, and try to educate them on things that they don't know. When they come in and they say they want something, in reality, it might not really be what benefits their case, and it may not really be what they want, and they'll figure that out as they go through. But if you can save them the headache of going through it and then being not happy that they went through it, it saves everybody, the relationship with the ex, whether they're going to have to work together for kids or just from general goodwill in life. If you don't have to ruin anything relationship-wise worse than you do, you don't have to spend extra time, money, and stress dealing with something. Just makes sense. Third, common sense. It's easy to kind of get sucked into, I think, what your client's trying to tell you, or working with the other side if they're being aggressive or maybe not making sense. But if you just kind of have that underlying perspective of, what kind of makes sense from a common sense standpoint and a big picture standpoint, it usually serves you very well. And then I also wrote, you need to have the ability to stand apart from your client. And when I say that, you've got an ethical duty to represent your client, and you're going to represent your client and do so to the best of your ability. But I think something that family law and all law requires the ability of you to be independent from them. They're going to try to, and this is easier to do too once you've done, when you start off, that's a pretty hard thing to do, because You haven't done a lot of them, so it's harder for you to see start to finish, where am I going with things. They've got 70 small things that are important to them, and you've got to be able to, through doing them, figure out which ones probably do matter more and which ones probably don't matter more, but you still got to tell them that. But the ability to be able to stand apart from them and tell them kind of why some of the things they want to do make sense and some of the reasons that the other things don't make sense, I think is huge, and it serves them better in the long run. And so I say that just with a kind of a segment to what you need to do, because they'll come into your office, and in the first meeting, you kind of got to figure out what are the issues. Are there minor children? Where's everybody living right now? Are you going to continue to live where you're living? Do you need to separate residences? If you're separating residences, where are the kids going to be? Who's going to pay the bills? Do both people work? Are you going to continue to use joint accounts? Are you going to separate all the money out? And you've got to kind of do a checklist of everything that needs to just pragmatically be settled as a sort of Band-Aid provision on a temporary basis, while you then work on what needs to happen until you can settle things on a permanent basis. And so when somebody comes in, you've got to go through what issues exist in the case. Do both parties work, or are there claims for alimony? How long has the marriage been? Has there been a long period of time where you've acquired property and debt together, or has there not been a long period of time where you've acquired a lot of property and debt together? What are the ages of the kids? And those kinds of things. And so in the first meeting, I'll just have you flip to, I think it's tab 4. I've got an intake sheet that looks like the beginning of it says your name.
There should be a page number at the bottom, which they would have.
It's Family Law Packet 002. This is just a general intake sheet where I have everybody list name, address, employment. I have place of birth and date of birth, but really we need to know just if they've lived, is there jurisdiction, have they lived in South Dakota, what county is this in general identifying information, and also for their spouse. And I typically ask, date of set, are you living together? Do you have the same address? Do you not? The date of separation, name, date of birth, and social security number for children. And then I also have a place for them to list the names of any previous spouse, just to make sure there isn't a conflict check. Like, for example, I've maybe represented the ex-spouse, or just, and it might not be a conflict, but just to identify information. And then you'll see, like, are you pregnant now, or are you not? Do you have a will? Today's date referred, and you'd be surprised how many times you actually do have some interesting answers to some of those questions.
I might add too, that intake sheet is valuable because most of the information on there just gets transferred straight over to the divorce complaint, because you have to state,
I agree,
a lot of that information just in the form, in the statutory requirements. So that's one of the reasons for that intake sheet.
I agree. And it's good for the file too, because you use it to call them, email them, etc. I'm now looking at Family Law Packet 003, the divorce initial conference checklist. And honestly, I drafted this probably a long time ago, just to jot my memory. When I met with people now, I don't really look at it so much, but I give it to clients. And these aren't necessarily things that everybody has in every case, but they're all potential issues as well as others that aren't listed. But just things that there's a certain checklist of things that you need to do if you're going to get a divorce too. You've either got to decide that financially you and your spouse can work together, and you can continue to say you don't have to, do you have joint bank accounts, joint checking, credit card, can you work together and use those, or does everybody have to go in and right then segregate and get separate accounts, kind of almost kind of fast and abrasively, and while we then try to figure out what's fair money-wise? Because a lot of times people will come in with a financial uncertainty, I'm not going to say crisis, but they don't know how to handle things, and they're getting divorced, and they don't have a lot of information for you that day about what their finances are, or they're not used to what that new arrangement looks like. So you've kind of got to be able to figure out with not a lot of information what you can do to get by until you get more information and have a chance to communicate on it better and get more organized, and then work out a solution. And so that's kind of an example of one of the things that when people initially come in, it can be handled very differently. So for example, if somebody has, I always say, all right, here's the lesser evil. If you've got an ability to communicate with your spouse at all, if the two of you can talk through how you're going to handle interim finances, you're going to save yourself, even if it's not pleasant, it's still more pleasant than the alternative. So if you can talk through your bills, and can you just, if you both work, you both put your money in a joint account, you both pay your bills like you have, and or same with kids. If you can make something work like that on the short term while we then get to a point where we're organized and are ready to split things out, you're going to save yourself a lot of stress, a lot of money, a lot of hassle, versus having to, say, have a temporary hearing on the issue of, whether it's custody, child support, alimony, etc. And you can do that, but it's not rocket science. It's going to be the same organization that you do talking between the two of you, but ultimately then you just go down with a limited window of time with a judge that's new to your case, who's going to hear a limited amount of information and kind of put a Band-Aid on it by issuing some temporary ruling too that you might like, or might be okay to get you until the judge hears more evidence. So, and that whole process is going to take you probably, just guessing, probably 2 months to get into the courtroom by the time you get the Minnehaha and Lincoln County. And I won't speak for all the counties, but those two are probably, in Pennington County, but two of the very busiest counties in the state. So to get even like a 1 or 2 hour hearing is going to take you that long. And so then you've got this 2-month limbo period while nobody knows what's going on, and you're waiting to get into court. And it's not ideal. And sometimes you need that hearing. If there's really no ability to talk with a spouse, or maybe one spouse is really controlling and is not fair and is not reasonable, then you probably need that hearing. But in the good majority of cases, people can work that out if they talk through it.
And this is the time, too, when the lawyer has an opportunity to temper the case. Because you can, in that period, you can start getting aggressive and setting the tone for the divorce, which will end up then in a trial, which may or may not get a better result. Some cases have to be tried. But that's the case where if you just immediately say, okay, we're going to fight about all this stuff from the beginning, and kind of give your client that message, it's a runaway train.
Usually what happens is if one person starts spiraling in a direction like this, then the other person, retaliates. And you got to think, right, when these two people, or let's say your client comes into your office about ready or starting a divorce, and the other one, they're very insecure, and they're already kind of hurt emotionally with the relationship, so there's always that feeling they don't want to lose to the other spouse. And so they're always hearing every possible thing they could be hearing from any outside whispering voice. And so once somebody does this, and it does. It spirals, and you figure out the cases where there's always a handful of cases where you probably have to go to court because usually one party, one side, or maybe both sides are flat out unreasonable. And unless you're just going to completely waive your rights and that kind of thing, you have to go to trial to have an impartial person make a fair decision. And there's always going to be that small percentage of cases, because I would say that is a small percentage. But aside from that, you've got I would say the big middle of like the curve that really, with a little bit of common sense, and you know what, you maybe you figure out this is an emotional week, things need to calm down, let's revisit this the next week, and try to get something done easier. So very, very true. And so I say all of that because usually if somebody comes in your office, all of those are the immediate things that you need to deal with before, simultaneous, or after with actually starting the divorce. So I think the next exhibit is it's the relocation statute, which I can come back to. But let's look at the summons and the complaint, which I think might be back here, guys. It's Family Law Packet 030. Summons and the complaint actually starts the lawsuit for a divorce, similar to a civil lawsuit. And that's kind of a big deal to a lot of people because they haven't been involved in a lawsuit before, and they actually have to start a lawsuit to start the divorce. And they have to understand that. And pretty much the documents, they're pretty standard. You don't see a lot of deviation. One of the issues might be, if people do have kids, don't have kids, you've got a few extra or not extra issues to add, and maybe the grounds for divorce. But pretty routinely, people use irreconcilable differences or in the alternative extreme cruelty as the grounds in an initial complaint. Every once in a while, people want to add another ground like adultery, or every once in a while something else. And that's okay to do. A lot of times I will actually say, why don't we start it this way? If things are not going well and it looks like we're going to be fighting or litigating over this stuff, then we can always amend the complaint. And if you're adding something and you've got the proof for it, then we can go ahead and amend the complaint and add the grounds, and that's typically fine. So they're pretty standard documents, all in all, really. Filing fee is $95 to file a divorce action, and gets the civil number, and then you can proceed from that point to get a hearing date and so forth if you need it. Just to walk through some of these other documents kind of quickly, the Family Law Packet 004 Relocation Statute. I think the reason I have this in my packet is just because it's a standard statute, and so it's going to apply in every case whether you want it to or not, and it just governs relocation. So if you get divorced and you have kids, you've got to give notice that you're going to relocate no matter whether you want to or not, if you want to take the kids with you. And that's an issue now that is not an easy one. It's not easy to move with kids if you've got two parents that are both at least somewhat involved with the kids. Used to be easier, it isn't as much anymore. The next form, Family Law Packet 005, is...
Just a minute, I might add about the kid stuff, the children stuff. Some people like to say that, I only do divorces where there's a lot of money involved or something. But when you think about it, there isn't anything more important in these cases than the kids. And so that is really probably the most important and most delicate issue that you'll ever have. It's worth a lot more than $100 million. I mean, and unfortunately, usually it's in the cases where people don't have money because they're young and they haven't accumulated yet. Usually the divorces where people come in and they have a lot of money to fight over. They're older, their kids are grown up, and kids are out of the picture. And so it's less emotional. And so it's really important to keep a handle on the children issue. And it's extremely, extremely important.
I agree, because probably more often than not, first of all, I think that both parents have to get a new perspective on what their parenting looks like if they're going to get divorced. It's not going to be the same as it has been. So for the person that's been, say, the primary caregiver, they're not going to be with their child as much as they were in the past, and that's a very big new reality that they have to get used to, and that's not always easy. And so I think there's that, but there's also a lot of times it seems like disputes with the kids is more about control than it really matters, honestly. And dickering back and forth when, and you know, and I've had, you know, lots of custody trials too, but they almost come down to an element of the ones that get tried, an element of control most of the time, more than it really mattered a lot one way or the other for the kids, in my experience. And maybe I'm being jaded when I say that, but the majority of good parents, I think, tend to settle custody cases because they can remove their emotion or hurt or sensitivity and figure out it's better for their kids to get something worked out. And you know, you may or may not have heard a couple of years ago, the legislature passed a statute that suggested that a judge consider 50-50 when making a custody decision. It doesn't require the judge, it doesn't give the judge for sure, yes, I have to do 50-50 custody. It just said, we'll consider. And surprisingly, it's had actually a pretty huge shift in what the judges have done, because they really almost then have used that, at least in my experience, as their starting point. And so they really have started to say, okay, unless you can tell me why one of the parents is a bad parent, you know, maybe somebody has an alcohol problem to the extent that they're, you know, not being responsible with small children. I mean, but the question is always, well, how severe is it? But they're really starting to try to neutralize it by giving a pretty shared custody arrangement to both parents. Now, that's not always, but by and large, it's changed a lot with the advent of that. It's not always easy to agree on it, and it doesn't always make it go away, but it's changed the landscape, I would say. So moving on, Form 005 is sort of I would say, kind of a general financial information form for somebody that maybe doesn't already have. A lot of people will come in and they maybe have authored financial statements for bank loans or other purposes, and they can come in and they have a financial statement for you, and that's nice. Actually, that's a super thing to get in a divorce case. And for a lot of reasons. One, it's a big picture simplification, and two, a lot of times if people have listed what things are worth, and then they come back later and try to claim that they're not worth that or that they don't have it, you've got kind of this nice, almost, it's not a cheat sheet, but it's just it's a very nice thing to have. And so a lot of times people will have a more sophisticated financial statement, or people come in, you should see some of the, you know, these anal, like, recitations of, like, their property, debt, monthly budget, etc. And they'll come in with their own forms, and that's great. But for people that maybe aren't as organized, it's just kind of a general idea. Assets, debts, budget, etc.
That's a good kind of gotcha, because you say to them, the other side, if they say, well, it really wasn't worth that much, so you lied to the bank, right? When you did it a year ago before you knew you were going to get your divorce. So financial statements are really a nice thing to have.
They are.
So it's either you're lying to us or you're lying to the bank if they change it up.
Form 011 is simply the SMILE program, which is a 1-hour mandatory requirement that you attend if you're a parent going through divorce. People don't like to go, but it's required. It's supposed to help you get along, working together afterwards. Form 013 is the South Dakota Parenting Guidelines. These were updated a couple of years ago as well. They had put together a commission, and they took the existing South Dakota visitation guidelines at that point and made small modifications throughout to that document to get to what is now the South Dakota Parenting Guidelines. And this is not law, but these are used by the judges as heavily as any statute in family law. They're really a fallback if you can't agree from a custody standpoint, from sort of general guidelines on communication, on being reasonable, on how to interact and those kinds of things, as well as minimums in parenting plans. And so in the cases where the judges need a fallback because their people aren't getting along, these are heavily relied upon. It's something that every client with kids should have and should read and should understand they're not going to be able to get around. Kind of period, end of story. And if you've got an exceptional case where there's abuse or substance abuse issues, physical abuse issues, then those will have to be handled individually, but those are very rare. So, and I should say on that token, you hear there's a lot of allegations that those are going on, probably more allegations than necessarily situations where the kids really are in danger, but you kind of got to be able to gather information, communicate, and try to figure out where to go with those issues as one of the things to handle if you've got a client or the other side who's really insistent that those issues are going on. And I think, and not to downplay the importance of something like that if it really is going on, but I think that there have been studies done that talk about the percentage of fabrication with respect to sexual abuse, physical abuse, and maybe exaggeration of drinking and so forth in the context of a divorce case when there's kids involved or there's a financial benefit in the proceeding. And you know, and it's interesting too if claims like that haven't been made and there haven't been issues with it prior, and then all of a sudden you're going through a divorce and something matters, like you don't want the kids to have to be apart from you or whatever, and then all of a sudden we've got these allegations. So you have to be careful with those. They're hard to ferret out what's really happening, and people have to understand the difficult. I mean, you've got to get specialists involved. If people really claim that those issues are going on, you've got to get counselors or home study experts or people that specifically deal with those issues to really come in and give an opinion on what's best for the kids, not say you as an attorney, not necessarily the parent, because you've got to get some expert advice, I think, on how to handle that. And it's very rare. It's very rare that it goes to that extent. Every once in a while you get one. Next form is 025, and this is a monthly budget form that I use. I encourage people to add any additional expenses they might have. But this is good for, one, sorting through interim bills that we have to split, but then also, two, any alimony claims. So if anyone's going to come in and say, you know, my spouse makes so much more than me, I can't afford to support myself, either in the interim of this or going forward, what's going to happen is you're going to have to get income tax returns. You're going to have to find out historically, or at least the last 3 to 5 years, what have people made, what are they making now, and what is everyone's monthly expenses. So as a starting organizational point, both sides are really going to have to fill out budget information, who's paying what bills and who's making what. And I would say when a divorce starts, I always tell people property and debt division is, I'm going to put it in the list of black and white issues in a divorce. There's plenty to fight over and there's plenty of ambiguity, but in general, it's one of the more black and white issues. Was the property accumulated during your marriage? You know, and there's always some questions there, you know, inheritance or maybe premarital assets, but for what happened during the marriage, it's pretty much going to be split Statute says equitably, but most judges do it 50-50. And that's one of the more black and white issues. Child support, there's a formula, or two formulas, shared parenting versus primary custodian. And those two issues are, at least to the extent they can be, more black and white issues. Something like alimony.
She likes those because she's a math major. She likes the simple math.
I always say alimony's gray. There is no formula. If you go in front of 5 different judges, you're going to get 5 different results. And you never know what you're going to get if you can't agree on it, and you have to end up in front of a judge. So everybody rolls the dice a little bit on the alimony issue. And it's usually maybe the hardest issue to settle too, because it's not a given, it's not a certain, it's tugging at everyone's everybody has a different perspective on what they think is fair. So anyway, it is able to be settled, but it's always probably one of the last issues to get settled, and it's great. But it's not rocket science. You've just got to put together income information and budget information, and I would say there's no set time when people get it or don't get it, but it's the disparity in the income and other factors as well.
And family members oftentimes try to influence your client. So their expectations of that might be way out of whack from what the law is, the judge. So that's one of the areas you need to really work with your client on. Mm-hmm. Particularly if they have cousins and brothers and sisters and next door neighbors that are telling them something that's really out of the ballpark.
Mm-hmm. And sometimes too, when you're starting everything and you're talking through all these issues, because a lot of those temporary issues are kind of smoking guns in the sense that everything's new for the divorce starting. So I feel like the emotion is sometimes at its highest. If it drags on forever, it escalates too, but things haven't cooled off. Nobody's figured out how to work together in their new way as much. It's that hard new definition of things, and so you try to calm it down, and you try to talk through it as much as you can, but every once in a while too, you get that gut sense that, my client or the other client needs to hear from the judge that they're not going to get everything they want. And if we go do, say, this temporary hearing on custody or support issues, it actually then, you kind of get that gut sense like, okay, let's have them both hear from somebody else. They're not both going to get what they want. And then they maybe figure that out, and you can maybe then proceed to settle the rest of the case because they kind of understand, oh, I've been in the courtroom. I don't get everything I want when I go in the courtroom. It's not as easy as saying, oh, you're not offering me what I want. I'm going to go to court. And then they realize, okay, well, the court option isn't super either. So then they kind of figure out from there, it's why don't I try to work together if I can get something reasonably fair with the other side. So anyway, there's a handful of times where you figure out we just need to hear something from the judge, and it probably then will help things settle. How am I doing for time? Form 038 is an answer and verified counterclaim. So basically, when somebody starts a divorce by filing a summons in the complaint, you technically have to answer the lawsuit within 30 days. Honestly, I don't think anything bad will necessarily happen if it's done reasonably within about 60 days, but technically you should have your answer filed within 30 days. And again, the answer is a pretty general answer, nothing too crazy, nothing too specific to the individual case, but more just a general pleading that...
There's probably not a judge in the state that would default somebody if they didn't appear with their answer until the 55th day or something. You can't default, you can't get a divorce until 60 days are up. And if somebody then appears in 50-some days and you bring a default down to the court, the judge is going to let that person in and hear both sides. So that's what Melissa meant when she said there probably isn't a lot of, it's not good practice to let it go past the 30th day, but the downside isn't real devastating.
I agree. And after you started the lawsuit and you kind of cooled down those interim issues, then you really work on how you're going to move the case forward to get to a permanent resolution. And so you've got to figure out, okay, are my clients really organized on financial matters? Or maybe there aren't that many financial matters, they're simple. Or, you know, is my client organized? Is my client not knowledgeable about the finances? Do I need as an attorney to gather the financial information, or is it already there? And so serving interrogatories is the way to get information if it's needed, either, you know, for financial reasons or other reasons in a divorce. And so you've got to figure out, do I need that step in this case or not? I would say in a large number, I would say a lot of times you don't, and a lot of times you do. And then you've always got the cases where you have 2 or 3 sets of interrogatories too, which is not ideal, but that's maybe one of those cases where you've got a lot of issues. So anyway, you've got the financial information gathering stage before you can then be organized to either try to draft a stipulation and agreement, which is basically a written contract that's going to cover every issue that needs to be covered that then both parties would sign. And that's the easiest, most ideal way to get a divorce done. It's voluntary. No one has to sign anything. And it usually is modified and different drafts are sent back and forth between the lawyers, but that's the easiest next way to then get a divorce finalized. If the stipulation and agreement can be signed, then it's just a matter of filing the judgment and decree in a couple of forms with the judge, and it can be done in a week or less if the judge is there and ready. So that's the easiest way. I mean, sometimes it's not quite that easy, and you can say schedule a mediation and go back and forth, and you hire somebody that acts as an independent mediator to go back and forth between both attorney and client A, attorney and client B, and really try to get them to bridge the gap and settle. But again, that's a voluntary process, so if somebody doesn't, if somebody wants to walk out, they can. Nobody has to agree, but that gets the job done a lot of times if that next step is necessary, and if that continues to fail too, then you probably have to have a trial. And you can always revisit settlement as you go forward. And sometimes cases settle once you get like towards the week or day of trial too. And then we just included 043 as a judgment decree of divorce. Again, pretty straightforward, pretty, you know, nothing too different case to case. A lot of times the judges will want 1 or 2 affidavits to establish jurisdiction and the grounds for divorce. Just kind of says what residence or what county people are in, that grounds exist for divorce, and your client signs them. It's arguable whether this document is always necessary or not. I think that there are different interpretations by judges and different, you know, one county to another county. Sometimes it's easier just to do it because it's a pretty simple document. But that's, I think in a nutshell, gives you at least a decent idea of process start to finish. And when I say I kind of took a lot of time at the initial step, but I think that there's oftentimes a lot of those initial issues that really do set the course for later on. And when you go through that step of gathering financial information, organizing it, and trying to settle, that can take anywhere from a short period of time to a medium to a long period, depending on the case and the clients. So anywhere from 2 months to 2 years. I mean, it could be worse, but just as a general, I think, range. So.
I apologize somewhat for us doing this in such a machine gun fashion, just keep talking and moving, but we do really want to get on the road, and I apologize for that. So we're kind of just throwing all this at you to give you an overview of what a divorce looks like. And you'll see in these forms that Melissa talked about, and for example, the form, and I don't know what number because it was renumbered by the law school, but the form that talks about the financial gathering and or the budget, and there's a form that asks for their bank accounts and do they have real estate, and it's kind of like a financial statement. That is our side of the fact gathering. And so the drafting exercise you'll have will be more like, well, we need to know what the other side says. Okay, you got your client in the office and you hear their story, and oftentimes you'll find out that there's not as much, particularly in divorce cases, because one of the reasons that people come to your office is the communication hasn't been the best. And so it's not uncommon for particularly females, but that's changing now because originally, more historically, they didn't have the bigger income and didn't own the business, but that's changing. But one side doesn't have a lot of information about the credit cards and what the business does and how much the income really is, because there's been hiding of it or suspect of that. And maybe there's been an affair and they think there's a lot of spending going on that's unaccounted for and that kind of thing. And so all of this gets thrown at you and you get your intake and you find out their budget. But what about the other side? It's not a one-sided story. So if you end up having to go to court, or even if you do that stipulation, you need to gather information that you don't have access to the other person. And you probably, I think you've all had civil procedure, right? And so you know what depositions are, and very seldom are depositions taken in divorces. They are. I mean, it's a method, you can use them, but they're more costly, and so oftentimes they're not used. So interrogatories are sent. They don't cost as much, and they have to be answered. And plus, then you can study them. And if you think they're incomplete, you can either try to get the other side through various methods to fill in the gaps, or you can do a deposition. You go to make a motion to compel, whatever. So now your drafting exercise is going to be trying to get information from the other side on the topics that I'll give you. And I've included, I think you all have the one we'll work for just as a sample today, but what do you do when you have an interrogatory? I mean, there's all kinds of general things like what's your name, who's helping you fill this out, that kind of thing. But then what do you need to know? Well, what are the topics in a divorce? Custody for kids, property, financial issues, whether it's child support or alimony, and then there are all kinds of sub-issues under that. There's financial and there's custody. There's just two sides, basically. And then there's sub-areas under both of them. So your client maybe says to you, and that's the sample that we'll go through, is that, well, I don't know if my husband or my wife, whichever side you're on, I think they may be they're claiming now, I thought we had this thing all worked out. You'll see that's the sample I got. They come to your office and they said, we worked through this thing. We tried to figure it out, but at the last minute, my husband, according to this draft, went to his attorney and said, not all this property should be divided 50-50 because some of it is marital property. There's not marital property. And so what do you as a lawyer have to know? If you hear that comment, your client isn't going to know what that means or what qualifies or doesn't qualify. So what do you have to do? You got to go research what are the elements of marital property versus other kinds. And then, or what if the issue is alimony? What do you have to do? You got to go research what are the elements, what are the 7 elements of whether someone should get alimony or not, right? So there's an element of having to know the law when you draft interrogatories, because otherwise, what's the purpose of your questions? So if you'll go to what is, according to this, I have page 1. How is that numbered? Do they on theirs?
No, it's just sample.
Okay, it's just that it's called teaching situation that talks about marital property. Y'all have that? I don't know what number it is in front of you. Okay, so in this fact scenario, I made it very simple and straightforward. Your client comes in and there's some concern about whether or not all the property that you're going to find out about. By the way, in your interrogatories, you'll be a lot more bigger in your scope than what we're going to talk about. But I'm just trying to kind of take off a piece of the pie and just talk about segments of interrogatories, because interrogatories oftentimes have lots of questions about all other kinds of topics. But we're just breaking off this one topic. And so what do you have to do when you hear that? You say to your client, well, do you know about any of these things? Do you know whether they inherited property or whether or not they had property they brought into the marriage or whether or not they got a gift from a parent like 6 months ago while you're already married? You know, it's that kind of thing. So they tell you what they know. Oftentimes they don't know all the situation. In this case, I set it up so they didn't know. Oftentimes they have some information. So if you go to then what's called the teaching example of a set of interrogatories, y'all have that. So now that you know, because you've looked at the law, and you know that at least 2 of the ways that that there can be an exception to this marital pot, because you divide the pot. You got a pot, and most judges divide it 50-50 after you figure out what the pot is. And of course, one of the fights is how do you divide the pot, who gets what property, but I mean, it's usually about 50-50 in value. So now they're saying some of this shouldn't be in the pot. It's over to the side, it doesn't count, and the rest of it gets divided 50-50. So you know that marital or property brought into a marriage of any substantial nature, and it hasn't been commingled and hasn't been used as marital property for some long term, might be subject to not being put in the pot. And you also know that if there's inherited property, maybe some family farm, it all came from the family, and it hasn't been used as marital resources, or maybe it partially has, it partially hasn't. There's all kinds of issues here. So what do? You got to ask questions to find that out. So let's look at some of this in the teaching example. You know, what I did is I didn't put in a big full set of interrogatories. But what I did, you see in the yellow, are yours highlighted, the copy you got? Okay. You'll see here that I did a few samples that aren't highlighted. It says, what's your name? And then if you go to the back number 25, and after you ask for some other things like, they're almost standard in every divorce, like I need the other side's income tax returns in case you don't have them. And you ask who, if they're going to have any witnesses, and are they going to have any experts, you know, like an accountant or somebody come testify. Those are in almost everyone. But these other questions that are highlighted are in a lot of them too, majority of them. But what do they seek? Look at them, and you'll see what they're attempting to do. They're specific questions to draw the other side out. They made that comment to your client before she came in. Okay, what are they? Tell me everything there is to know about them. And here are some examples of how you do that. Look at number 18, for example. If you were just to ask the question to them, well, did you have any inherited property, yes or no? Where does that get you? Nowhere. So look at number 18. You ask a general question, did you receive anything like that? And you know, or did you own anything and any kind of property prior to the marriage? And if they say so, then for each one of those items, you want a description, you want an amount that they're claiming is a credit against the marital estate, you want the value at the time of the marriage, if it's something they took into the marriage, and so on. You see all of that, and if you don't ask those questions, you're not going to get anywhere. You're just going to be fact gathering in any lawsuit, including a divorce, is the crucial part of it. Because if you don't have the facts, you can't make decisions and you can't help your client. So, and then number 19, you're asking about, possible whether or not that's relevant or not. You're asking, are you now or have you been, or do you expect in the next year the beneficiary of a will? Maybe some future bequest or expectation is not relevant in the case, but I mean, what you're doing is, as you know from your civil procedure, discovery isn't limited to what necessarily is admissible in a trial. You have wider, you could go after things that would lead possibly to admissible evidence. And so that's what a lot of these do. It says, now look at number 20. If you feel that any of the items described are non-marital property, then it asks all these particular subparts about what to do, or about what you can gather so you can analyze the case. And then you go to, you talk about debts, and you talk about debts that were premarital too, because remember, debt, I always call debt property. It's just negative property. So you got to know about it, whether it's brought in, and then sometimes I ask a question about whether or not, how it's been commingled, so you look at part B there. But I also ask a question, not necessarily on this subject matter here, but what is it they're claiming, or what is it that they understand about our clients' finances, personal life, if there's alimony involved, fault, all these other kinds of issues that aren't necessarily on this topic, may or may not be, but so you don't always ask them about what they have. You sometimes ask them about what they know about your client. And so you want them to say it, because then if you go to a trial and you've asked the question in interrogatories and they come in with something that is brand new, that they could have responded, that would have been responsive to a question, but they didn't respond, that technically the judge isn't supposed to allow. So that's why it's important to be complete. Now, your assignment that you're going to be getting, let me back up a minute. You oftentimes can develop pretty good interrogatory questions by going back to your very own fact gathering that Melissa went through. I know it's not sexy or exciting to go through, we'll read this file, but I wanted you to see what a file looked like. And you can probably take this, if you go into practice, you can probably, make sure the statutes haven't changed, but a lot of these forms can be used. I mean, they're good office practice items, the checklists and so on, because lawyers miss things in cases. No matter how much experience you have, you might just forget to do something. But if you have a checklist and you don't check it till it's been done, and you've got it there, then you don't miss things. And that's really important, because missing things is one of the big fears that all lawyers have. Did I forget to file something? Did I miss a deadline? Did I forget to ask this? Your checklist solves that problem. Now, the student assignment you will get deals with alimony. And I tried to throw a lot more facts in it than this little short one I gave you. And I broke it into two parts. I'm going to ask you to draft 4 interrogatories on each subpart of alimony. And so one of the items is going to be finding out financial sources, 4 questions about financial sources. Now, you don't have this yet, but you'll get it. I understand you get it at 6 o'clock today or something. So I want you to ask questions on me tomorrow when you call, because I think it actually will be much easier to draft interrogatory interrogatories for the ones I'm giving you in the teaching assignment because I made it more factually complete. And I'll give you some tips. Those factual indications in the fact scenario should help give you ideas about question stacks. And so I'll ask you to draft 4. They don't need to be, I'm not looking for the 4 questions that will solve the whole issue of that particular topic. I just want 4 interrogatories, and you may say, oh my gosh, there might be other things I should find out on that topic. Well, don't worry about that. Just do 4, because I want to see whether or not you have applied the law. You're going to have to go read some cases on alimony and look at the statutes. The statutes probably you already know. It's pretty basic, like support, but it's the cases that really define the elements. And so one of them is a financially driven set of questions, 4 of them, and the other one has nothing to do with money. It's the other grounds of divorce. Now I want you to draft those, and then we'll see how you do. Now, if you go back, if you ask the question, for alimony, what is your income? Well, it's not going to be very good. So you need to think. You need to fight through that, and you need to think of all the possible elements that might be involved in that. And you can use subparts. But I would caution you that if you use too many subparts, you might get all 4 interrogatory questions in one, and then you say, well, how do I get the other 3? How do I draft them? So you can make an interrogatory with 50 subparts if you wanted to. I mean, some lawyers do that, and so that's the end of it, but I want you to do 4. But don't just ask a bullet question like, what is your income for a financial part of alimony? I mean, you might ask that question, but then what else goes with it, okay? And but I've supplied you with more facts and gave you assumptions of facts so you've already done some fact gathering from your own client. The teaching example that we went through, everything was resolved when your client walked in except for this one topic. That's not the case in your assignment. So when Melissa went through all these things that are in a typical file, a lot of them, except for the complaint a little bit, but except for the like the summons and except for the divorce decree and those things, they are indicators, if you really think about it, they're indicators of what would go in interrogatories. You've got that financial intake, family law packet 005. Well, that would be a pretty good, everything you need to know from your client, don't you want to know it from the other side? So it's just phase 2 of representing a client, fact gathering. Once you have all the facts, you got to learn how to deal with your client. Half of a divorce representation is fact gathering and application of the law. The other half is handling the people involved, people management. And so this part that you're being asked to do now is more the fact gathering and the application of the law. And once you get it, it doesn't mean you'll know what to do with it because you might have an unusual client, but it's still what you need. And remember how I started this, 70% of disciplinary complaints to the State Bar Disciplinary Committee come from divorces and criminal law, but a majority of that 70% is family law related. And it's usually because my lawyer didn't do this, didn't represent me aggressively enough or something. And a lot of those are dismissed because you understand that what the lawyer did was the right thing. But oftentimes it's they're complaining against the lawyer on the other side because they're obnoxious to them. They call them, they examine them in a hearing or in a trial, and they said personal things about them that were unnecessary to further the case or to get a resolution. So if you keep it factually oriented, that's one of the reasons I thought interrogatories would be good this year, because if you remember to just analyze the facts and keep it really boring, just go to work every day and keep your temperature the same, and your clients often will follow. And this should help you. This packet should help you if you ever do divorce law when you get out here. And I think that's the purpose of this course, is just to have a practical application of a subject matter. And we tried to do a really fast overview of that. It's probably machine gun and it gets a little boring after a while, but if you remember that almost all of it applies to the fact gathering and interrogatories too, you'll be okay. So, when do they get it at 6 o'clock? Is that right?
Yeah.
Okay.
My one comment on when you're doing the interrogatories, kind of start with the general premise that people tend to be non-responsive. So when you draft your question, I think that's what he was saying, when you draft a general question, people will give you a small amount of general information back. So if you want something specific, you got to specifically ask for it. And even then, sometimes it's a struggle, but at least you've done what you need to do to get the ball rolling.
Yeah. Think of it this way. If they can answer the question in a way that is only a partial truth of what you're wanting, or it's a yes or no, you haven't gotten anywhere. So, and the other side will do that.
They will.
They will do that. So you have to ask, what size shoes do you wear? Really, yeah. It's not a very good example, but you actually have to ask all the specifics under any topic, or you won't find out. So, particularly with interrogatories. In a deposition, it's easier because you might say, what's your income, and you listen to them rattle off, and then after you've heard their answer, then you can adjust and ask them all these subpart things that they haven't responded to. But when you do it in writing, you don't get that follow-up question because you don't know what their answer is going to be. And it's usually not going to be one you like, or it's not going to be complete. Do you have any quick questions? I know you don't have your drafting example yet, but I mean, it's, have you done interrogatories in civil procedure? Have you had to draft them yet? Haven't? You've studied them though, right? You know their section of the code, and I gave you the statutes and the discovery statutes, and so you might want to give those a quick overview before you get started. And I'm not asking you, if you go to number 19, the teaching example, I kind of showed you a heading and I did some kind of preliminary.
The heading lists the statutes too for interrogatories.
Yeah, right.
Request for production.
And so, but I'm not asking you to do that part. I just if you want, just like go to page 3 of that set of examples we gave you, or page 2. I just do the interrogatories, the questions. Don't forget about all this preliminary stuff. I don't expect you to know how to do that, or if you wanted to, you could just copy what I had. It doesn't mean anything. I want you to really, I want to see how you think through the topic and apply the law to what facts you need to apply to that law. So you have to know the law before you know what facts to ask for. Okay?
The drafting exercise will come out at 6, and we can, if everyone can come tomorrow with at least one question that we'll pose during our phone conference to Tom. And this was, even though you went through quickly, it's been a very valuable presentation, and the resources are extremely valuable. So I know when I took this class, these kinds of resources are really the things I've referred to as I've begun a practice. So we're really thankful for your generosity in making your way to the law school today and sharing these things with.
Well, the older I get, the more afraid I am of the road. So I used to.